Legal passage. Start. According to concise Oxford Dictionary, the word willful means the action or state for which compulsion of ignorance or accident cannot be pleaded as excuse, intentional, deliberate, due to perversity or self will. The House of Lords has also made it clear that to establish that the disobedience is willful, it is not necessary to show that it is contamination in the sense that there is a direct intention to disobey the order. It is sufficient to show that effective administration of justice requires some penalty for disobedience to the order of the court if it is more than casual, accidental, or unintentional. The essence of the civil contempt is willful disobedience to any judgment, decree, direction, order, or writ of a court, and not mere inaction to give effect to it. The conduct of the alleged contemner must be willful, showing deliberate and conscious disregard of the court's order or a despising or disdainful attitude towards the verdict of the court. Mere inaction on the part of the government or its servants to take any action to reinstate a decree holder and grant him all the benefits and privileges or services will not amount to contempt of court, but where it has wilfully and deliberately refrained from giving effect to the decree, a case of contempt may arise. On this issue, the view of the Punjab and Haryana High Court appears to be more correct and pragmatic. It has observed that from the dictionary meaning of the term willful and the decisions of the court, it is reasonable to derive that the term willful disobedience used in section 2b of the Contempt of Courts Act 1971 cannot be construed to mean that an act must be all designed and deliberate to be held as civil contempt. If a party who is fully in know of the order of the court or is conscious and aware of the consequences and implications of the court's order, ignores it or acts in violation of the court's order, it must be held that disobedience is willful. Ordinarily, it is never practicable to prove the actual intention behind the act or omission. A court can approach the question only objectively, and it may presume the intention from the act done, as every man is presumed to intend the probable consequence of this act. Willful disobedience cannot be construed to mean that act must be designed or deliberate. In Ashok Paper Kangar Union versus Dharam Godha, the court has well explained the meaning of willful. According to the court, willful means an act or omission which is done voluntarily and intentionally and with the specific intent to do something the law forbids, or with the specific intent to fail to do something the law requires to be done. That is to say, with bad purpose, either to disobey or to disregard the law. It specifies a deliberate action done with evil intent or with a bad motive signifies a deliberate action or purpose. Therefore, in order to constitute contempt, the court of the order must be of such a nature which is capable of execution by the person charged in normal circumstances. It should not require any extraordinary effort, nor should be dependent either wholly or in part upon any act or omission of a third party for its compliance. This has to be judged having regard to the facts and circumstances of each case. Whether the disobedience has been willful is an issue to be decided by the court, taking into account the facts and circumstances of the case. However, in deciding this issue, it is better to have in mind that every man is presumed to intend the probable consequences of his act. If, after considering facts and circumstances of the case, the court derives a conclusion that the disobedience is not willful but it is due to compelling circumstances of impossibility of compliance with the order, the contemner may not be able to liable to be punished for the contempt of court. If, having regard to all the circumstances, the court does not conclude beyond all doubt that the alleged contemner had acted wilfully, the court will give benefit of doubt to the contemner. The court, while considering the issue as to whether the alleged contemner should be punished or not, having complied with and carried out the direction of the court, has to take into consideration all facts and circumstances of a particular case. That is why the framers of the Act, while defining the civil contempt, have said that it must be wilful disobedience to any judgment, decree, direction, order, writ, or other process of a court. Before a contemner is punished for non compliance of the direction of a court, the court must not only be satisfied about the disobedience of any judgment, decree, direction, or writ, but should also be satisfied that such disobedience was wilful. If, from the circumstances of the case, the court is satisfied that although there has been a disobedience, but such disobedience is the result of some compelling circumstances under which it was not possible for the contemner to comply with the order, the court should not punish the alleged contemner. Where the person alleged to be in contempt is able to place before the court sufficient material to conclude that it is impossible to obey the order, the court will not be justified in punishing the alleged contemner. If it is proved that the compliance with the order was impossible, the alleged contemner is not punished for contempt. However, mere difficulty is not allowed as a defense. In short, if all possible steps have been taken by the officer responsible for the implementation of the order, he should not be punished for the contempt of court. For example, the action for implementing the court's order generally requires its passage through different bodies, but the officer concerned in emergency has power to take action required for implementing the order of the court. He must take such action. If the meeting of the bodies is not held on account of want of quorum, etc., if the meeting is held and the meeting takes a decision against the wish of the officer responsible for implementing the order and the officer has no power to override the decision of the body and the result is that the order is not implemented, it is not proper to punish the officer for contempt as he has not disobeyed the order willfully. Although in such condition the body which has taken decision resulting in non-implementation of the order may be held liable for the court. However, if the officer has power to override the decision of the body, he should exercise his power so that the order of the court is complied with, and if he does not do so, he may be held liable for contempt. However, care must be taken so that it may not result in a method of willfully avoiding the order of the court. An example of such attempt is found in the case of Ramesh Chandra Srivastava versus J.R. Chowdhury. In this case, the order was not obeyed on the pretext of want of necessary approval, while the approval had already been given. In a case, the High Court directed for completing the selection process for the post and published the result. The candidate could not be appointed because no appointment to the post could be made without the prior approval of the state government, and the government subsequently abolished the post. The court held that there was no contempt of court. The candidate could not claim the right to the post. Besides, the direction was to complete the selection process and publish the result, and this was done. There was no direction that he should be appointed. In a case, the contemner did not furnish bank guarantee before the arbitrator despite the undertaking given before the Supreme Court. In addition, he sold away the only property in his possession.